Hi, my name is Michael Entz. I know what you're thinking. Hey, Maurice, look, they got some fancy male model coming in to do a video. No, it's just me. I'm one of the lawyers here at Entz Burton Associates, and we've been doing estate planning since 1987. Now, my internet people asked me to do some short videos to define certain terms they thought would be useful to our public. But they said I got to do it in 3 to 5 minutes because I can't hold anybody's attention longer than that. So today we're going to talk about revocable trust. Let's go to the first one. Every time you see me do a seminar, we're going to start out with this slide. Estate planning breaks down into 4 themes: intangible costs, tax costs, transfer costs, asset protection. Today we're in this one. Let's go to the next slide. Basically, there are only 3 ways to transfer the title of your assets to the next generation. At your death, everything you own is either going to pass by operation of law, through a trust, or through probate. For most of my clients, we want to avoid probate, so we arrange their assets to pass by operation of law and through a trust. So let's go to the next one. Now, what is a trust? As I mentioned, Black's Law Dictionary is admissible in a court proceeding as a true definition. Now, they spend about 4 pages defining what a trust is. And so, by definition, this is going to be incomplete. So don't implement this until you've talked to a professional that's familiar with your situation. So, what do they say a trust is? A right of property, real or personal, held by one party for the benefit of another. Another one here, any arrangement whereby property is transferred with the intention that it be administered by a trustee for another's benefit. Okay? So another way to think about this is that the trustee owns the property, but he must use it for the benefit of the beneficiary. When I was in law school, my property teacher told me that a trust was like a stick of bologna. The outside skin is owned by the trustee. The inside meat is owned by the beneficiary. If you have your choice of being the trustee or the beneficiary, what do you want to be? You want to be the beneficiary. They get the popsicle, okay? The trustee, he just manages the property. A trust has many terms and many uses. Again, in our practice, we use them mainly to avoid probate. Let's go to the next one. Basically, all trusts are either revocable or irrevocable. I say again, all trusts are either revocable or irrevocable. If they're revocable, you can set them up on Monday. You can change them on Wednesday. You can do away with them on Friday. Okay? An irrevocable trust is pretty much set in stone. So as long as you've heard the term living trust, loving trust, inter vivos trust. Those are just different names for the same thing. What you want to know is, no matter what you call it, is this trust revocable? And if this trust is revocable, then you're not getting in over your head. You can change it. Okay? Let's go to the next one. All trusts, and especially revocable trusts, have 4 parts. They have a settlor, they have a trustee, they have a beneficiary, and they have this thing called a fiduciary duty. A settlor, sometimes called a trust maker or grantor, is the person who sets up the trust. A trustee is the person who manages the trust property, and a beneficiary gets the use and enjoyment. Now, how do you know that your successor trustee is going to do what you said to do after your death? Because he is bound to that he's bound to that beneficiary by a fiduciary duty. Fiduciary duty is the highest standard of care possible under the law. And if I'm your successor trustee, I better do what you told me to, or I've opened myself up for a lot of problems. So you don't have to go to court to distribute a trust, but you can use a court to enforce the terms of the trust if you have a bad actor. Okay, let's go to the next one then. Basically, as estate planners, we have a whole bunch of different tools that we use. These are some of the more common ones. You will not need all these. It depends on your situation. But we have a revocable trust, an irrevocable trust, Testamentary trusts are just trusts that are set up by your will. You can't have a testamentary trust without a probate. A charitable remainder trust allows you to make a gift to charity, retain a lifetime benefit off that gift, and get a current income tax deduction today for a gift that will occur at your death. We'll do a whole video on that sometime. And then family limited liability companies, family limited partnerships we don't hardly use anymore. This revocable trust with the B trust clause is that example I showed you earlier. So, typically a person serves in all three spots. We talked about that. A revocable trust, we can't overemphasize this enough, a revocable trust remains changeable as long as you're alive and competent. Because you have access to those assets, though, it does not protect you from creditors. It does not protect you from nursing home claims. It does not protect you from any kind of lawsuits. It's a revocable trust. This is that revocable trust with the B trust clause. Now, typically you would use this when you had a marriage, a second marriage late in life. You might have a revocable trust, which is changeable as long as that settlor is alive. Then at their death, everything goes into this irrevocable trust, which can't be changed. It pays an income to that surviving spouse. If you've decided to write it in, then they can have access to the principal. But at the second death, then your assets will go to the children of the first marriage. Okay? We used to use this a lot in estate tax planning because of the unified credit, and this taping, the unified credit amount is over 12 million, so it's not that big a deal anymore. Next one. So, before we get to this, what should you do? One of the questions I want to ask you or answer is, someone always asks me, well, who should I pick for my successor trustee? You do not need someone with great business skills or legal skills to be a successor trustee. You need someone who has good character and a sense of fairness. The rest of that stuff they can hire. So pick someone who has good character and a sense of fairness. They can hire accountants, they can hire lawyers, they can hire investment advisors, they can hire all that stuff, but you can't hire character. Okay, now then, what should you do generally? Well, at some point you're going to have to assemble the facts, and you're going to have to develop a plan. Now, to do that, I think you need to talk to someone who's familiar with your personal situation. Then you need to implement that plan. You got to take the action step. Lastly, you got to review that plan every 3 to 5 years. Now, please remember that we're Oklahoma attorneys, and we only work for people who live in Oklahoma or have property in Oklahoma. We hope that if you're out of state, you can find some of this information useful, but remember, you must get it confirmed by an attorney who is licensed in your jurisdiction. So thank you for your time. We look forward to the chance to working with you. If you're an Oklahoma client, please call us at our toll-free number, 1-800-633-7230. Obviously, you know our website, or you wouldn't be looking at this, www.savestaxes.com with 3 S's. Call us up. We'll give you a free initial consultation. We'll talk about your situation, design a plan. There won't be any obligation to go forward until you tell us that's what you want to do. Again, thanks, and have a wonderful day.
Hi, I'm Deja, the Disclaimer Girl. This video is intended to provide general, non-specific information for Oklahoma's persons and property. Please get an attorney before you act on any of this information. Remember, Entz Burton is only licensed to provide legal service in Oklahoma, but I can disclaimer anywhere in the world.